Entrepreneurship Cell, Ghaziabad. She received BTech in EC from G.B. Pant University of Agriculture and Technology, followed by Masters from VIT Pilani and pursuing PhD from Banasthali Vidyapeeth. She is certified in managing startup incubation and ecosystem by IIM Lucknow and a certified expert in IPR by Indian Law Institute Delhi. She has more than 10 years of experience. She is a mentor expert in institute innovation councils of various reputed universities and institutions. She has also has a research patent in her name. So these are just few of the achievements of ma'am, and there is a long list of this. So now, not taking much time now, I invite ma'am to share the views on the present topic. Welcome, ma'am.
Yeah, thank you so much, Shashank sir. And this is my privilege to be here among you all. I'm very much thankful to management and director Deen Dayal Upadhyay Management Institute and the entire organizing committee for inviting me for this impact lecture series on IPR and IPR uses in trade and development. So I feel honored to be a part of this impact lecture series sponsored by Ministry of Education, and apart from this has been really a great exposure to be connected with Deen Dayal Upadhyay Management Institute as a part of Institution Innovation Council collaboration, and definitely we are working collaboratively in this special direction while we talk about entrepreneurship and innovation. So thank you so much to the organizing committee, and now with the permission of the Chair Director Deen Dayal Upadhyay Management Institute, I would like to put up my presentation on this one of the important topic of IPR.
Ma'am, kindly share your presentation.
Yes, thank you. Is it? Screen is visible, sir?
Ma'am, presentation is not visible here.
Yes. I'm just making it. It must be visible now. Yeah. Kindly confirm that this is visible now. Is it visible?
Ma'am, the screen is visible, but it is not a full screen.
It's not full screen.
Yes, it is visible.
Is it visible now? It's in full screen mode, sir. This is in full screen mode from my side.
It's not visible now.
Yeah. Is it in full screen mode, sir? Kindly confirm.
Screen cannot be seen now.
Yeah.
You are out of the presenting mode.
Yeah, it's in full, it's in a full screen mode.
No, ma'am, screen is not visible. It is not in presenting mode.
Oh. from my side, I'm making it in slideshow mode. Is it fine now? Yeah.
No,
Shashank sir?
ma'am, it is not visible here. Ma'am, you are not in presenting mode.
I am in presenting mode. I have from my side, I am making it in slideshow mode.
तो आगे जो स्टार्टिंग में स्टार्टिंग में जब सीखना शुरू करेंगे तब आगे
Let me see it again. Again, let me try to share it.
शुरू में उसकी आगे थी प्रेजेंटेशन, उसने फिर छेड़
Is it fine now?
उसको बोलो दोबारा से शेयर करे स्क्रीन.
Yeah, sir, is it fine now?
Ma'am, still now you are not in presenting. No, ma'am. Ma'am, share the screen, ma'am.
I don't know what the problem is. Let me try to make it another way round. From my side,
Yes, ma'am. Now it is visible. Now your screen is visible.
is it in full screen mode now?
Yes, ma'am. Yes, ma'am.
Yeah, thank you
Now-
so much. So sorry, these are some technical
Yes,
differences.
ma'am. Yes, yes, ma'am.
Yeah. So thank you so much once again, and this is again very important to share while we talk about intellectual property right and how this is related with trade and development, because this is the major objective behind commercializing one of the intellectual property right, to make it available in the market, to trade it and to commercialize it. So before starting, I'll be having a quick recap just to connect with the earlier content of the lecture series. So when we talk about patent, we need to understand that patent is a right given to a person over the creation of his or her intellectual property. Anything, any design, any form of write up, any kind of new process is like an intellectual property created by a person, and like we have a right on a physical property, similarly this is a right given to a person on the intellectual property created by the inventor. Now, what is the uses of the patent if we talk about? So, as like in our physical property, we need to have it registered from the authority to ensure that nobody else is going to make any illegal right on my property. This plot, this house belongs to Mr. X, has to be done through a legal process, through registration to the legal authorities. So similarly, in case of intellectual property, to prevent others to use to steal your intellectual asset and to get it in your credit by your name, to earn money from this intellectual property, like we get in physical property by renting it, by selling it. So the similar process to get benefit from your intellectual property, the entire intellectual property right process takes place. So if we summarize that how the various type of intellectual property right may be associated with one product. So for a very very simple example which we use in our daily life, we used to purchase various drinking soft drinks, some even water as well. we have various brands. So let us understand how one product may be a composition of various type of intellectual properties. Single product and multiple intellectual property rights may be taken by the inventor. So first of all, let us see the content inside the bottle. What the chemical formation of this drink is. That is the subject matter of patent. And one of the very famous example of Coca-Cola, the trade secret example, because nobody till date knows the composition of the Coca-Cola drink, and this has been made a trade secret, and rights, intellectual property rights has been taken by the company itself. So this lies in the subject matter of patent. What is the composition of the drink which the person is going to consume? Another seal, as I would like to put up another example, like we used to have straw while we used to drink any juices and any fruity etc. We have a particular straw over there to drink it. So the design of this straw, how the seal has been made, what kind of design has been used, what a particular process has been used, not design, what the particular technique has been used to seal the bottle. That is again a matter of the subject matter of the patent. Now come to the brand, which brand it belongs to. This is of Bisleri, this is of some Tata has also launched its own water. Nowadays we all are drinking various soft drinks like Maja, like Lohari Jeera kind of. So the subject matter of trademarks come under this brand name. What brand name has been put up on the product. Another very important aspect is how you are going to hold this bottle, what the design, outer aesthetic of the bottle is. This belongs to the subject matter of design. So this was a very simple example to explore how one product can be a composition of various intellectual property rights to be taken by the inventor. And another example which we may explore is the mobile phone which we are having in our hand. What the design of the mobile phone is, what features are there, and we can say the type of display, type of technology, which brand, which version. So these are all the different type of intellectual property rights to be claimed by the particular company for single product. So let us try to understand why do we need to register a patent. What is the need of the intellectual property right, as we were summarizing in the starting. So first, the foremost reason is to stop anyone from copying my idea, to stop anybody to steal my innovative product, my innovative design, my content, my recording, my voice. So this is first of all to make it to make it to ensure it that this particular innovation belongs to this particular person only, and the credit created by this intellectual property right in the terms of money, in the terms of name and fame, goes to this particular person only, who is the inventor, creator of this intellectual property. Then to increase valuation of your company, this is really a very big aspect to understand, that how many patent lies in the favor of a person or a company. Like we have the number of patents, the number of intellectual property we have in our portfolio, it enhances our value. And we can understand it very simply, like a person who have number of physical properties that defines the social status in terms of richness for a person. Similarly, for a company, for a person, in terms of intellectual asset, defines the number of intellectual property created by this person. So the company having patents, various sort of patents in its portfolio is to be, getting its branding in the market easier, and a popular product to fetch the maximum monetary benefits out of it. To gain market edge and credibility. Definitely, today we trust on Tata. Today once we are looking for food, while on the way we look for Haldiram, we trust Bikaner, we trust some specific brand. So to gain the trust of the market, to enhance your customer base, this is something to have in your portfolio, that these innovative products, these initiative lies in the portfolio of this particular company. Sources of revenue, as we are talking, that once you have intellectual property in your portfolio, be it a person, be it a company, the company can license to the another company, and can generate enormous revenue out of the intellectual property created by the company or an individual person. Other benefits, if we talk about for the creation and protection, then definitely what was happening earlier, that we can understand it very simple example of academia itself, that what was happening in the recent past, that the student used to work for their final year project, and these innovative ideas used to kept in the library in the project report form, but nobody was able to take the credit of such intellectual assets. So once you have this intellectual property right in your hand, either you can implement it and can generate revenue, or you can license or sell to others to make it available to the public. So as we can understand, this stops the mere collection of such intellectual property. Rather, it would be possible for the public to use such innovations to make the human life easier. As we were talking, increasing value of the company, increasing its brand value, and can be sold or licensed. When you have achieved the patent, you have got the right on your intellectual property. Now you will be able either to license it or to sell it to the third party and get the monetary benefits out of your intellectual property, which was not in trend just a decade ago. People were not that much aware, and one person was doing some innovation and other people nearby was copying it after some time, and this person was not able to get the credit of the innovative the innovation created by this person. Then can be used for negotiations during acquisitions and mergers. Suppose there are two companies. One company has some patents, some designs, some trademarks in its portfolio, and now when they are going to merger, so one company having better intellectual property right portfolio would be having better negotiations, would be able to have better monetary benefit, would be able to put up a higher value proposition to the another company. and attract collaborations. One, the person having various intellectual property rights in the portfolio would definitely be a person of value in the market. Similarly, in case of a company having various intellectual property rights in its portfolio would be much more valuable in the market, and people will be ready to collaborate to get the license of the innovation and to use it in the market. And we can consider various examples over here. Suppose we take an example of mobile phone. Some new feature has been launched by one mobile and it is getting popular in the market. Now another company, like we can take example of Nokia. Nokia was not in touch phone technology earlier, and it was obsolete within a span of maybe 1 or 2 years in the market, while the entire market was covered by the Nokia just maybe 7-8 years ago. So now Nokia will be purchasing the technology from the other mobile companies who are who are the frontliners and can use this technology to upgrade its product. So in the form of licensing or in the form of technology transfer, this collaboration can be done, and now both of the parties would be in a win-win situation. One party, the owner of the intellectual property, would be earning by the monetary benefit by licensing it to another, and another company will be manufacturing by having the rights through the intellectual property rights. So this is how the business, how the trading would be at ease for both of the parties, and it will finally lead to the growth of the economy, and will be supporting the development of the industrial sector, and accordingly the nation will be developing slowly by such initiative and collaborations. So very quickly we would like to say what is the process of obtaining a patent. It might have been already covered. So as we know, first of all we need to ensure the idea is unique. With the help of patent prior art search, it can be ensured by the attorney or the person who is well educated in the area, that this particular idea has not been in the public before this process of filing. Now, drafting and filing a patent application in the patent office, you need to be aligned with the process of the various forms given by the IPR office to give the details of your innovation, so that it may be examined by the concerned authorities to ensure that this unique product is not already available in the market, or any such information has not been there in the public domain. Then step 3 comes to as publication of the patent application by the patent office, that this particular innovation has been filed by this Mr. X, and such innovation is not already lying with some another owner. So this publication is done by patent office. It's kind of a publication in the public domain, that if anybody having such innovation, they can report to the IPR office, and again it may be checked whether it has been in public domain in terms of any news, any research paper, or any kind of appearance in some competitive event. This has to be ensured through the process of publication. Then step 4 come as the examination of the patent application. This again has to be done by the concerned authority in IPR. Examiners are there. Controller of the examiner in patent office will be evaluating the application after filing the first examination report by the concerned authorities. And after step-by-step examination, as per the claims, objections may be given and some hearings may be required. As per the objection put up by the patent office, the inventor has to answer all those queries to satisfy up to the last question of the IPR authorities, and then disposal of the patent application depends upon the quality of the patents, whether this is unique or not. One very important aspect here to consider is that patents are territorial in right. One patent filed in India will be applicable in the periphery of the Indian government only. So once we are talking about the commercialization of the product, we are talking about the trade of a particular product, then this patent need to be filed in each country separately at the global, as a global patent.